Good afternoon, everyone. So we are the Group 4, and today we will be going to discuss to you the Big Picture B, week 4 to 5 in our sim. And today we will be going to explain the principles of law and obligations and contracts. And we will be going to discuss also the different rights, obligations, and consequences in entering into a contract of sale. I am Noeme Jane V. Burlas.
I am Kristal Gayle Canatoy.
And I am Oscel Cabungcag.
And we are the Group 4. And now we will start on discussing the essential terms that will be used in this section are defined below of our collective understanding. And these are 15 definition of terms. And the first one that we're going to discuss to you is Miss Oscel Cabungcag. Oscel?
Active subject. So it is the person who has the right or power to demand the performance or payment of the obligation or called as creditor. Sample is contract loan, wherein the active subject is creditor. Other sample, the company is the debtor and the bank is the creditor, which is the money is owned. The next is the casual fraud. So it is basically a deception used by one party prior to a simultaneous with the contract in order to serve consent of the other and to convince other person to enter into a contract. The next is the contract. So a promise enforceable by law, which is that promise do something or refrain from doing something, that making contract require mutual assent, and one of them making offer and another is acceptance. So the example of the contract is the employment contract. Next is dependent. So a person or group against whom a criminal or civil action is brought and also being accused or breaking the law and being in court. So the example is someone accused of driving under the influence. The next is the delay, means the act of postponing or delay or agreement of the parties to do something by law. Bads.
So for the continuation, we have here the lack. It is an act by which one person by fraud or malignity causes some damage or tort to some other. The lack, an offense against the law. In addition, the lack comes from the Latin word delectum, which means legal wrong. The basic elements of the lack are conduct, wrongfulness, false accusation, and damage. It is also said that it is essential to realize that all 5 elements mentioned above must be present before a person can be said to the delictually liable. So next is incidental fraud or dulu incidente, a fraud that was committed during the performance of the obligation. Incidental fraud here is supported by Article 1344. In order that fraud make contract variable, it should be serious, not have been employed by both parties. Incidental fraud only oblige the person employing it to pay damages. Next is instrument, the paper where the contract was written. Legal instrument is a legal term of art that is used for any formally executed written document that can be formally attributed to its author, records and formally expresses a legally enforceable act, process or contractual duty, obligation, right, and therefore evidences that act, process, or agreement. Example of these instruments are contract, affidavit, power of attorney, will, legislative act forms, and etc. Next, we have here juridical tie. It is the vinculum or that which binds the debtor and creditor. Juridical tie is the vinculum juris. It is also known as the juridical or legal tie. Other authors call it the efficient cause. It is that which binds or connects the parties to the obligation. In other words, it is the legal relation between the debtor and the creditor. Next, we have here The last we have here negligence. It is the omission of the diligence required by the nature of an obligation and corresponds to the circumstances of a person, time, and place. So failure, so in negligence, failure to use reasonable care resulting in damage or injury to another.
So for the continuation, for 11th definition of term is the obligation. Obligation is a juridical necessity to give, to do, or not to do. Or it is the moral or legal duty that requires an individual to perform things or to pay for something under legal terms. For example of this is a person has an obligation to pay for his speeding ticket within 60 under the state law in North Carolina. And another example for this is a person obligations to repay a mortgage loan when you buy a house. And second one is a passive subject. A passive subject, it is also known as obligor or debtor. It is the person who must fulfill the obligation of the presentation. It is that the other meaning also of this is that it is the person is bound or has the duty to fulfill the obligation, and it is called debtor or obligor. And let's emphasize the word an object or presentation. It simplifies the subject matter of the obligation. Example, a contract of loan wherein the active subject is the creditor and the passive subject is a debtor. And the word presentation there is a money to be borrowed and efficient cost is the contract. An example for this also is that, for a scenario, Romeo executed a contract of loan to borrow money from Juliet, whom he wishes to spend in courting Juliet. So Juliet in return agreed and lent money to Romeo. The meeting of the minds of Romeo and Juliet created the contract of loan, and to enforce what they have agreed upon they put it in writing, or the contract of loan, which is what the statute of fraud demand. Another one is a prestation. Prestation is the subject of the obligation either to give, to do, or not to do. It is the subject of the obligation either to give, in the present. It is the object of obligation either, and the presentation to do is a positive personal obligation. An example for this would be the obligation of a painter to create an artwork for the person who will be going to commission him. And the other one is the quasi-contract. Quasi-contract, it is an obligation that the law creates in the absence of an agreement between the parties. It is an obligation that the law creates in the absence of agreement between the parties, and also it is an obligation imposed by law to prevent unjust enrichment. It may also be presumed by a court in the absence of a true contract, but not where a contract either expressed or implied in fact. And it can be distinguished into two types. First is the negotiatorium gestio and the solution indemnity. First one is the negotiatorium gestio. It is the voluntary administration of the property, business, or affairs of another without his consent or authority that creates an obligation for reimbursement for the necessary expenses that the gesture had spent. For example, for this is when Juliet left her farm unattended for 1 week because she is having a vacation, Romeo, a concerned lover in secrecy, noticed that Juliet has not been around and plants are slowly dying. Out of the affection, Romeo cultivated the land, watered it, buy some fertilizers and placed the first fertilizers to the plants, remove the weeds, and do all what a farmer should do. Romeo spent necessary expenses which needs to be reimbursed in order for Juliet not unjustly enrich herself at the expense of Romeo. The next is solution indemnity. Solution indemnity refers to the payment by mistake. it is not receiving payment. It is receiving payment by mistake that is not due or does not have such right to demand such payment. It creates an obligation to return such payment. An example for this is when Romeo borrows goods from Juliet's store, and the good cost 1,500. Romeo gave 2,000, so the store cashier and received a change of 700. Romeo duty bound to return the excess of 200 to the store. Otherwise, he will be unjustly enriching himself at the expense of Juliet's store. So that would be all for the 15 definition of terms. And now we proceed to the next topic. The first objective of this week is to understand the basic principles of the law on obligation and contracts and how this law creates a relationship between parties. We will be discussing thoroughly the essential topics that we need to learn in this section. So first article will be discussed by Oscel Cabungcag.
Okay, the continuation. So first article is 1156. An obligation is a juridical necessity to give, to do, or not do. Article 1156, which is the obligation, meant here is only those obligation which is not performed by one party. The one party go to the court to enforce the obligation to pay for damages, but not all obligations are enforceable before the courts. The next is the elements of the obligation. So first is the passive subject. So passive subject, it is a debtor, the one who is responsible for fulfilling the obligation. Example, me borrowing money in a bank, so me is the debtor and the bank is the creditor. Next is the active subject. So active subject, a creditor that has the power to demand the fulfillment of the obligation. In the previous sample, which is the bank, is an active subject. So next is the prestation. So prestation is the object of the obligation. So example is contract of sale and a contract of loan or a contract of labor or a contract of the service. So next is judicial tie. So it is a legal tie in which binds the parties to the obligation. Other words, it is the legal relationship between debtor and the creditor. The next is the sources of the obligation. So the first sources of obligation is the law. So it is the set of rules created by the state institution. So example of the law is don't drink and drive. So next is the contract. So under Article 1305, a contract is a meeting of minds whereby one binds himself to others to give something. It is like a promise between people. So example is the employment agreement. So next is quasi-contract. So it's the obligation imposed by the law to prevent unjust enrichment. So example is, let's say you pay for a pizza to be delivered and pizza is delivered to another house. So, and someone else enjoy it. So, it a quasi-contract could be initiated. It aims to prevent one party from unfairly benefiting from the situation at the other party's expense. So, the next is neglect or the act or omission punishable by the law. So, a crime is defined as an act of omission which is made punishable by law and gives rise to action in favor of the victim. So example is if a person causes damages to another, he must compensate the injury party. So Next is quasi-delect. So, act the case damage or the cause damage or harm to the another person, since from the acts a duty arises to compensate the damages or harm caused the victim. So example is, Pedring broke the window of your office while playing baseballs. So Pedring pay for damages even without existing contract. So the last is the next is the Article 2180. So which means demandable not only for one's own act but also for those person for whom one is responsible. So example of Article 2180 is that Thomas is a driver of biyahe travel and tours, and one of his function is to pick up guests at the airport, but along the way he accidentally bumped the person, which is cause of his death. So the company is responsible for damages caused by their employees, especially it happened on the occasion of their function. Bads.
Okay, so before Kristal Canatoy continue the discussion, let's go back to the definition of terms because there is another definition of terms that is not um, being discussed. So the last one for is the quasi delect. So quasi-delect is it is an act whereby a person without malice but by fault, negligence, or imprudence not legally excusable causes injury to another. So the quasi-delect is an act whereby a person without malice but by fault, and it is also known as the tort or culpa actualiana. It is obliged to pay for the damage, but without any pre-existing contractual relationships between the party. And for example, for this is Anthony, a handsome, try-hard baseball player, was playing baseball outside Caitlin's house. And upon seeing Caitlin, Anthony suddenly got excited and hit the ball so hard that it flies straight to to Caitlin's window, shattering into pieces and bounced right Caitlin's face, injuring her beloved nose. And though Anthony and Caitlin's has no contractual relationship at all, they are not bound to each other because of quasi-delect. Because of Anthony's negligence, he will be liable for the damages that he done to Caitlin or to what happened on Caitlin's nose. So now for the continuation of the article, Kristal, Ethel, Canatoy will continue.
So for the continuation of the article that Miss Oscel Cabungcag read is fourth, sources of damages, liability, Article 1170. Please ko po, Miss Noeme, ano sa slide.
Wait.
Again, fourth, sources of damages, liability, Article 1170. Those who in the performance of their obligations are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor, therefore, are liable for damages. So for the explanation of this article, the article gives the four grounds of liability which may entitle the injured party to damages for all kinds of obligations. And this article refers to incidental fraud committed in the performance of an obligation already existing because of a contract. So we have here fraud. Fraud has two types. It is incidental fraud and casual fraud. So first is incidental fraud. Incidental fraud is supportive by the Article 13 1344, in order that fraud may make contract voidable, it should be serious and not have been employed by both parties. Incidental fraud only oblige the person employing it to pay damages. So, example of incidental fraud is Mr. Guno enter a contract to deliver 500 kabans of rice to Miss Ria with a price per kaban of 1,300 pesos. Mr. Guno delivered 300 caravans but withheld the delivery of the remaining, stating that the price and priced the rice to 1,600 per kaban. The fraud here is dulo incidental, which is incidental fraud, because it is committed to the existing contract. So it is clearly stated here in my example that Mr. Guno was cheated or scamming Miss Ria for the price of the per kaban. So next is casual fraud. Casual fraud is in contract. A fraud known as dulo consente or casual fraud is basically a deception used by one party prior to or simultaneous with a contract in order to secure the consent of the other. Next slide, please. We have here negligence. One of the obligations of the obligor is to observe due diligence in the performance of his obligations. Hence, if the diligence required was not observed, there may be a liability. Okay, for the negligence, failure to use reasonable care resulting in damage or injury to one another. Okay.
Okay, so for the continuation of the discussion, it is on, we will be going to have a second video because the time here is already on 40 minutes.